Before we begin, a quick and important disclaimer. The information presented in this video is strictly for educational and entertainment purposes and does not constitute professional, legal, financial, or tax advice. The American divorce attorney sector is a highly complex, heavily regulated, and strictly state-specific landscape. Laws, judicial precedents, and procedural rules vary drastically from one jurisdiction to another across the United States. Any historical trends, potential outcomes, or case studies discussed today are meant solely to illustrate broader macroeconomic and structural shifts within the legal industry, not to provide specific guidance for individual legal disputes, personal family law matters, or asset protection strategies. Always consult with a licensed, qualified legal professional in your specific state before making any decisions regarding a divorce, asset division, child custody, or any other related legal proceeding. Relying solely on the macro analysis provided in this educational deep dive, without conducting your own exhaustive due diligence or securing proper representation carries significant inherent risk. $50 billion. That is the estimated annual economic footprint of the divorce industry in the United States alone. When the average person hears the word divorce, they immediately think of the emotional toll, the shattered families, the bitter custody battles, and the profound personal grief that accompanies the end of a marriage. But beneath the surface of those deeply human tragedies operates one of the most resilient, recession-proof, and systematically efficient wealth transfer mechanisms in the history of American capitalism. While the broader national economy experiences volatile boom and bust cycles, while the tech sector faces massive localized layoffs, and while domestic real estate markets freeze under the immense pressure of rising interest rates, the business of marital dissolution continues to grind forward, almost completely insulated from traditional macroeconomic corrections. We are looking at a unique sector where the primary raw commodity is human conflict, and the billable hour is the engine that converts that conflict into staggering localized wealth. Consider a recent historical trend that has fundamentally reshaped the modern legal landscape. Over the past 3 decades, the sweeping transition from fault-based to no-fault divorce across the country was heralded as a progressive social victory. It was sold as a way to streamline an archaic, punitive system and reduce the agonizing friction of ending a marriage. However, from a strictly economic perspective, this legislative shift inadvertently transformed the entire family court system. Instead of spending time in court arguing over who was to blame for the demise of the relationship, the battleground shifted entirely to the complex valuation and meticulous division of marital assets. We moved from arguing over infidelity to employing armies of forensic accountants to trace obscured cryptocurrency wallets, untangle nested limited liability companies, and project the future value of restricted stock units and executive compensation packages. This evolution birthed a highly specialized, hyper-lucrative ecosystem of auxiliary legal and financial professionals. The average contested divorce in the United States now routinely drains tens of thousands of dollars from middle-class households, and in high-net-worth brackets, the legal fees alone can easily surpass the gross domestic product of a small municipality. But here is the most controversial statement you will hear today. The system is functioning exactly as it is financially incentivized to function. The architecture of the American divorce attorney sector is not fundamentally broken. It is a perfectly optimized market designed to maximize billable hours through the strategic management and prolongation of emotional distress. Yet, there is a massive seismic shift occurring in the background right now, an open loop that the mainstream financial media is completely ignoring. We are witnessing a quiet revolution involving private equity firms actively lobbying to buy up legal practices in states like Arizona and Utah that have begun deregulating law firm ownership. We are seeing the rapid implementation of predictive artificial intelligence in settlement modeling, threatening the traditional associate attorney business model. And we are facing a demographic tidal wave of high-asset gray divorces among the baby boomer generation, a demographic that holds the vast majority of the nation's privately held wealth. These intersecting historical trends and technological forces are about to radically alter how family law is practiced, priced, and profited from. If you do not understand the underlying mechanics of this industry, you are completely blind to one of the most powerful economic forces operating in the shadows of American society. Today, we are going completely under the hood of the American divorce attorney sector to give you a definitive macro-level masterclass on the business of family law. For the United States audience, whether you are a prospective client staring down the barrel of a potential separation, a law student observing the evolving legal market, an entrepreneur looking to disrupt the legal tech space, or an institutional investor analyzing demographic trends for capital deployment, the fundamental problem you face right now is a total lack of systemic transparency. The family law sector operates entirely behind closed doors, protected by strict attorney-client privilege, sealed court records, and a prevailing cultural taboo that prevents open, clinical economic analysis of the industry. This video solves that informational asymmetry. We are going to map out the exact business models that currently dominate the space, moving step by step from the solo practitioner operating on depleting retainers to the massive, multi-state family law conglomerates that operate exactly like corporate litigation defense firms. We will break down the fundamental unit of this economy, the billable hour. We will explore how the inherent, unspoken conflict of interest between a client's deep desire for a swift, painless resolution and a law firm's fiduciary requirement for partnership revenue generation creates highly predictable market inefficiencies. You will see through detailed case studies how the increasing complexity of the modern American household portfolio has created an absolute boom for tertiary industries. We will analyze the specific economic roles of vocational experts who determine earning capacity, child custody evaluators who act as private judicial proxies, and business valuation specialists who apply aggressive discounts to marital assets, all of whom act as necessary tributaries feeding the main river of attorney fee generation. Furthermore, we will examine specific jurisdictions that have attempted to disrupt this lucrative model through mediation mandates and collaborative law models. We will analyze the historical trends of these alternative dispute resolutions, detailing why some have succeeded in lowering the barrier to entry for working-class families, while others have simply added another expensive layer of preliminary billing before inevitable, full-scale trial. By the end of this deep dive, you will possess a crystalline, uncompromising understanding of the economic incentives driving the American divorce machine. You will know exactly how law firms assess the financial viability and collection risk of a new client during the initial consultation. You will understand how managing partners forecast the life cycle of a contested dissolution to manage their firm's cash flow, and how broad macroeconomic factors like inflation, stock market volatility, and housing market liquidity directly dictate settlement strategies on a national scale. You are not just going to learn about family law today, you are going to learn about the ruthless business of the law. We are stripping away the emotional narrative, the societal guilt, and the personal tragedy to reveal the cold, hard economic realities of the American divorce attorney sector. To understand this machine, you must first understand its fundamental unit of currency, which is the billable hour. Unlike personal injury law, which operates on a contingency fee model where the attorney takes on the risk of losing, or estate planning, which relies on predictable flat fees, the American family law system is overwhelmingly tethered to hourly billing. This creates an immediate and undeniable structural friction. Imagine if you hired a contractor to build a house, but instead of agreeing on a final price, you agreed to pay them a premium hourly rate with no established cap, while simultaneously giving them the authority to decide how many hours the project required and allowing them to benefit financially from every single delay, argument, or change in the blueprints. This is the exact economic architecture of a contested divorce. The inherent unpredictability of human emotion during a separation is the very mechanism that makes flat fees impossible and hourly billing astronomically profitable. Every text message sent in anger, every petty disagreement over a holiday schedule, and every delay in producing a tax return represents a localized revenue event for the representing firm. This economic life cycle begins with the initial consultation. The general public often views this first meeting as a legal therapy session, a safe space to unload years of marital grievances. However, from the perspective of the law firm, this meeting is a rigorous, calculated underwriting process. The attorney is not just assessing the legal merits of the case. They are conducting a forensic audit of the prospective client's balance sheet to determine the absolute ceiling of extractable capital. They are looking at liquid cash, available credit limits on high-yield cards, the equity in the primary residence, and the complexity of the retirement portfolios. They are evaluating the opposing spouse's personality profile to forecast the likelihood of protracted litigation. A highly agreeable opposing party represents a low billing ceiling. A narcissistic or highly combative opposing party represents a veritable goldmine of billable hours, requiring endless motions to compel, emergency hearings, and status conferences. Consider a specific scenario set in the current year of 2026. Imagine a standard upper-middle-class couple, David and Rachel, living in the suburbs of Atlanta. David is a mid-level director at a logistics company with a compensation package heavily reliant on restricted stock units and performance bonuses. Rachel owns a successful local digital marketing agency operating as a single-member limited liability company. When Rachel walks into a premier family law firm for a consultation, the managing partner immediately recognizes a high-friction, high-yield asset profile. The firm requires a standard $20,000 evergreen retainer just to file the initial petition. To the average citizen in 2026 grappling with inflation and tightening credit markets, $20,000 feels like an immense sum of money. But in the microeconomy of family law, that retainer is merely the opening ante, the venture capital required to fund the initial stages of discovery. The firm operates on a classic leverage model. The senior partner bills at $700 an hour. The junior associate bills at $400 an hour. The paralegal bills at $200 an hour. The strategy is to push as much volume down to the paralegal level as possible, generating massive profit margins on administrative tasks, while reserving the senior partner's premium rate for courtroom appearances and high-level strategy sessions. Within the first 45 days of David and Rachel's case, that initial $20,000 retainer is completely incinerated. It is consumed by the drafting of the original petition, the back-and-forth negotiations regarding temporary child support, the creation of mandatory financial affidavits, and the countless unavoidable email chains between the two opposing law firms. Every 6-minute increment of communication is tracked, logged, and billed. When the retainer dips below a mandatory $5,000 threshold, the firm halts all meaningful progression on the case and issues a demand for immediate replenishment. If the client cannot liquidate assets or borrow funds from family members to meet this demand, the firm will file a motion to withdraw as counsel, leaving the client stranded in the middle of a complex legal battlefield. This brings us to the most lucrative and financially devastating phase of the modern American divorce, which is the discovery process. Discovery is the formal legal procedure where both sides exchange financial information and evidence. In theory, it is designed to create transparency. In practice, it is weaponized paperwork. It is a highly effective revenue engine that thrives on attrition. For a case involving complex assets like David and Rachel's, discovery is not a simple exchange of W-2 forms. It involves serving exhaustive interrogatories, which are dozens of deeply intrusive written questions that require hours of attorney time to draft, and even more time for the opposing side to answer. It involves drafting subpoenas for years of bank statements, cryptocurrency exchange records, credit card histories, and corporate tax returns. Once these thousands of pages of documents are secured, the firm then charges the client to have associates and paralegals meticulously review every single page, searching for hidden assets or dissipated marital funds. This system operates perfectly within the boundaries of legal ethics, yet it heavily incentivizes the over-litigation of minor issues. If David disputes a single line item on a credit card statement from 3 years ago, claiming it was a non-marital business expense, Rachel's legal team is financially incentivized to spend thousands of dollars of her money investigating that claim, even if the disputed amount is only worth a few $100s. The cost of the investigation rapidly eclipses the value of the asset in question, but the client, blinded by the emotional desire to win the argument, willingly funds the expedition. The legal professionals are simply fulfilling their duty to be thorough, leaving no stone unturned, while systematically draining the marital estate in the process. But what happens when the assets become so incredibly complex, so deeply layered in corporate structures, trusts, or decentralized finance protocols, that the attorneys themselves can no longer confidently evaluate them? What happens when a law firm realizes that simply billing for document review is no longer sufficient to maximize the economic potential of a high-net-worth divorce? This is the exact moment when the family law firm activates a secondary network of highly specialized, incredibly expensive third-party professionals. They open the gates to a shadow economy that the average client does not even know exists until they are forced to pay for it. The attorney ceases to be just a litigator and transforms into a general contractor, outsourcing massive segments of the case to external financial mercenaries who hold the power to completely destroy a spouse's financial future. You are about to see exactly how these shadow professionals operate. Welcome to the battlefield of the retained expert. In the high-stakes arena of American family law, attorneys are ultimately bound by their own lack of financial specialization. A lawyer cannot testify to the value of a commercial real estate portfolio, nor can they legally audit a decentralized cryptocurrency ledger. Therefore, They must outsource this function to a shadow economy of business valuation experts, forensic accountants, and vocational evaluators. But you must understand a critical, unspoken reality about these professionals. They are not impartial agents of the court seeking an objective financial truth. They are highly paid, sophisticated financial mercenaries hired to construct a mathematical narrative that overwhelmingly favors the spouse paying their retainer. This creates a hyper-expensive phenomenon known in the industry as the battle of the experts, where the marital estate is systematically drained to fund opposing financial fictions. Let us return to the year 2026 and examine Rachel, the digital marketing agency owner we discussed previously. In a standard corporate merger or acquisition, Rachel's business would be valued based on a straightforward multiple of earnings before interest, taxes, depreciation, and amortization. But in an American divorce proceeding, the valuation of a privately held enterprise is an incredibly malleable, subjective exercise designed to be weaponized. David's legal team immediately hires a premier forensic accounting firm to value the agency. Their mandate is to inflate the value to the absolute highest defensible number, thereby increasing the payout David will receive. They look at gross revenue, project massive future growth based on highly optimistic 2026 market trends, and conclude the business is worth $5 million. Rachel is suddenly facing the terrifying prospect of having to buy out David's fabricated $2.5 million share of a company he never worked for. To combat this existential financial threat, Rachel's attorney must counter-deploy their own business valuation expert. This expert is given the exact opposite mandate, which is to shrink the perceived value of the agency into oblivion. They achieve this through aggressive, perfectly legal accounting mechanics known as discounts for lack of marketability and discounts for lack of control. They argue that because Rachel is a single-member owner, the business cannot be easily sold on the open market. Furthermore, they deploy the most devastating weapon in the valuation arsenal, a concept known as personal goodwill. Rachel's expert argues that the agency only generates revenue because of Rachel's specific, unique relationships with her clients. If Rachel were to be hit by a bus tomorrow, the business would be worthless. Therefore, the value of the business is not $5 million, but rather a mere $400,000 of hard assets like computers and office furniture. Now, take a step back and look at the macroeconomic reality of what just occurred. You have two highly credentialed financial firms looking at the exact same tax returns and bank statements, yet producing valuations that are $4.5 million apart. Each of these experts charges a flat fee of roughly $40,000 for their comprehensive reports, plus an additional $500 to $600 an hour to testify in court. A family court judge who typically has a background in public defense or general litigation rather than complex corporate finance is then forced to choose between these two extremes. Historical trends show that judges will frequently split the difference, creating a completely arbitrary compromise value. The only absolute, mathematically certain outcome of this entire process is that $80,000 of marital wealth has been permanently transferred to the tertiary divorce sector. But the extraction does not stop at the business owner. Consider the employee spouse holding modern, complex compensation packages. In 2026, corporate America heavily relies on restricted stock units, deferred compensation plans, and performance-based equity grants. Tracing the marital component of these assets requires a forensic accountant to dive into years of vesting schedules. Imagine if David was granted 10,000 shares of his logistics company before he married Rachel, but the shares did not vest until 3 years into the marriage. Are those shares separate property because they were granted before the wedding, or are they marital property because the labor required to vest them occurred during the marriage? A forensic accountant will spend 50 hours, billing at $400 an hour, running sophisticated tracing algorithms known as a time rule formula to carve out the exact marital fraction. And if David happens to be technically savvy and has attempted to shield his bonus payouts by purchasing Bitcoin and transferring it to a cold storage hardware wallet, the forensic fees will explode. Blockchain analytics firms are routinely retained by divorce attorneys to track public ledger movements, turning a simple asset division into a digital espionage operation that can easily cost the estate another $30,000. Perhaps the most insidious of these shadow professionals is the vocational evaluator. This role specifically targets the concept of spousal support or alimony. Imagine a different scenario. Consider Michael, a surgeon making $700,000 a year, and his wife Sarah, who left her career as a pharmaceutical sales representative 10 years ago to raise their 3 children. When they divorce, Sarah files for substantial spousal support to maintain the lifestyle established during a decade of marriage. Michael's legal team immediately objects and hires a vocational evaluator. This evaluator essentially conducts a hostile mandatory career assessment on Sarah. They test her skills, analyze the 2026 labor market statistics in their specific metropolitan area, and produce a staggering report claiming that Sarah is willfully underemployed. They will argue that despite being out of the workforce for 10 years, Sarah could easily secure a management position earning $150,000 a year within 6 months. The court takes this completely hypothetical, fabricated salary and imputes it to Sarah. This means that when the judge calculates Michael's monthly alimony obligation, they pretend Sarah is already earning that $150,000, drastically reducing the amount of real money Michael actually has to pay her every month. The vocational evaluator charges $10,000 to create this fictional reality, saving Michael hundreds of thousands of dollars over the next decade, while leaving Sarah facing an immense financial deficit based on a job offer that does not actually exist. The entire ecosystem is a brilliantly structured web of wealth extraction, carefully designed to turn a family's life savings into billable hours and expert witness fees. It is a system that thrives on complexity, opacity, and the absolute destruction of mutual trust between spouses. But as devastating as this private financial warfare is, it pales in comparison to what happens when these cases finally escape the private offices of the attorneys and enter the public domain of the courtroom. What happens when your entire financial future, your retirement, and your relationship with your children is handed over to a single elected official who operates with absolute, unchecked immunity? What happens when the state itself becomes a financial stakeholder in your misery? The answer is that the courtroom itself is transformed from a hall of justice into a highly efficient, administrative processing plant where human lives are systematically broken down into taxable, enforceable, and monetized line items. Welcome to the American family court system. To understand the macroeconomics of this sector, you must completely discard the television drama version of a courtroom. There are no juries in the vast majority of family law trials. There is no panel of your peers waiting to weigh the moral complexities of your failed marriage. Instead, your entire estate, the access to your children, and the trajectory of your future are placed in the hands of a single individual, a family court judge operating what is known as a court of equity. In the American legal system, a court of equity grants the presiding judge astonishingly broad discretionary power. They are not strictly bound by rigid formulas in every scenario. Rather, they are tasked with determining what is legally fair and equitable. From a macroeconomic perspective, this immense, localized judicial discretion is the exact engine that drives the massive litigation industry we have been analyzing. Because the outcome of a trial is heavily dependent on the individual temperament, biases, and mood of a single judge, the system is inherently unpredictable. And in the business of law, unpredictability is highly profitable. If the outcome of every divorce were mathematically certain, there would be no financial incentive to litigate. The uncertainty is the product being sold, forcing clients to pay exorbitant hourly fees simply to try and sway the vast discretionary power of the bench in their favor. But the economic realities of the courtroom extend far beyond the judge's bench. The state itself operates as a silent, heavily incentivized stakeholder in the dissolution of the family unit. This brings us to a massively overlooked component of the macro analysis, Title 4D of the Social Security Act. Enacted in the 1970s and heavily expanded over the subsequent decades, Title 4D was originally designed to help welfare recipients collect child support from absent parents, thereby reimbursing the government for public assistance. However, historical trends show that this system rapidly evolved into a sprawling billion-dollar federal matching program that encompasses millions of middle and upper-class families who have never touched the welfare system. Under Title 4D, the federal government pays state governments massive financial incentives based on their performance in establishing and enforcing child support orders. States literally receive federal matching funds, often at a rate of 66 cents for every dollar spent on child support enforcement administration, plus additional performance bonuses based on the total volume of money collected. This creates a staggering conflict of interest at the structural level. The state infrastructure, including the family court processing clerks, the state disbursement units, and the child support enforcement agencies, is financially dependent on the continuous generation and enforcement of new child support orders. Imagine if you are looking at this as a purely corporate model. The federal government is the venture capital firm, the state government is the localized franchise, and the divorced parents are the mandated consumer base. In the current year of 2026, the technology used to track, garnish, and extract these funds operates with ruthless algorithmic efficiency. Once an order is entered, wage garnishments are automatic. The state intercepts tax refunds, suspends driver's licenses, and freezes bank accounts to ensure compliance, effectively acting as an incredibly aggressive, federally backed debt collection agency. The family court is the intake valve for this massive federal funding machine. Let us examine how this plays out in a real-world high-retention case study. Consider John and Emily, living in Cook County, Illinois in 2026. John is a commercial architect, and Emily is an administrative director for a hospital network. When Emily files for divorce, the court backlog is immense. It will take 18 months to get a final trial date. To manage the interim period, the court holds a temporary orders hearing. In a matter of 20 minutes, based on aggressively drafted financial affidavits and minimal actual testimony, the judge issues a temporary order dictating child support, temporary alimony, and exclusive use of the marital home. Because the judge has minimal time and vast discretion, these temporary orders frequently default to highly conservative, standardized formulas that overwhelmingly favor the receiving spouse to prevent them from needing state assistance. John is suddenly ordered to pay thousands of dollars a month to Emily, while simultaneously paying his own rent for a new apartment and attempting to keep up with his legal retainers. Here is the economic trap of the temporary order. It immediately alters the balance of power. Emily is now receiving a steady flow of tax-free child support and taxable spousal support, while remaining in the fully furnished marital home. She has zero financial incentive to settle the case quickly. John, conversely, is bleeding capital at an unsustainable rate. He is experiencing the crushing pressure of the state's automated enforcement systems, knowing that if he misses a single payment because he had to pay his attorney, his professional architectural license could be suspended by the Title 4D agency. The legal system utilizes this manufactured financial attrition as a primary tool to force settlements. John will eventually run out of money to pay his legal team, forcing him to accept a highly unfavorable final settlement simply to stop the bleeding. The court system relies on this financial exhaustion to clear its heavily congested dockets. Furthermore, because the judge does not have the time or resources to personally investigate the intricacies of John and Emily's parenting dynamics, the court forces the parents to privatize the judicial investigation. The judge will appoint a guardian ad litem, or a private child custody evaluator. This is yet another shadow professional forced upon the family. The guardian ad litem is essentially an attorney appointed to represent the best interests of the children. However, the state does not pay for this service. John and Emily are ordered to pay the guardian ad litem's hourly rate, which easily matches their own attorney's rates, often reaching $300 to $400 an hour. The guardian ad litem will visit their homes, interview their children, speak to teachers, and then write a comprehensive report recommending a custody schedule. Historically, family court judges overwhelmingly adopt the recommendations of the guardian ad litem. This essentially means the parents are paying tens of thousands of dollars to an unelected, private attorney who has been granted the de facto power of a judge. If the guardian ad litem's report is unfavorable to John, his only recourse is to pay his own attorney to depose the guardian ad litem and hire a separate rebuttal expert to challenge the methodology of the report. This circular firing squad of billable hours is not a malfunction of the family court system. It is its defining architectural feature. The court outsources its investigative duties to the private sector, mandates that the citizens fund the investigation, and then uses the resulting financial devastation to compel a resolution. But this economic attrition is merely the standard operating procedure for a typical contested divorce. What happens when the standard legal playbook is deemed insufficient by a deeply vindictive spouse? What happens when an attorney realizes that the fastest way to secure absolute leverage, seize immediate control of the marital assets, and permanently separate a parent from their children is to deploy the nuclear option of family law? We must now examine the darkest, most controversial, and arguably most effective tactical strategy utilized in the modern American divorce sector, a strategy that circumvents due process entirely and weaponizes the criminal justice system for civil financial gain. This tactical strategy is colloquially known within the industry as the silver bullet, and legally, it manifests as the ex parte order of protection or the temporary restraining order. To comprehend the devastating macroeconomic efficiency of this maneuver, we must examine the intersection of civil family law and the criminal justice system. In a standard civil proceeding, due process is the foundational bedrock. You have the right to be notified of the allegations against you, and you have the right to present a defense before a judge alters your life. An ex parte order completely bypasses this constitutional safeguard. The Latin term ex parte translates to from one party. It means that one spouse, guided by their legal counsel, walks into a courthouse and presents a narrative of fear or impending harm to a judge without the other spouse present, notified, or allowed to defend themselves. Historical trends clearly demonstrate that family court judges, operating under immense political and social pressure, are highly incentivized to grant these temporary orders. From a strictly judicial risk management perspective, if a judge denies an ex parte request and a tragedy subsequently occurs, their career is over. Conversely, if they grant the order based on an exaggerated or entirely fabricated claim, the worst potential outcome is that the accused spouse is temporarily inconvenienced until a formal hearing can take place. Therefore, the mathematical default is to grant the order. However, what the judicial system views as a temporary, 2-week inconvenience is actually a catastrophic financial and psychological ambush designed to secure absolute leverage in the divorce proceeding. Let us examine a highly specific case study set in the current year of 2026. Imagine a couple, Thomas and Laura, residing in a high-cost living market like Seattle, Washington. Thomas is a senior systems architect, and Laura manages a portfolio of short-term rental properties. They are in the preliminary stages of a highly contentious separation, but are continuing to cohabitate in their primary residence because liquidating a $3 million home in the current 2026 interest rate environment is financially suboptimal. The tension in the house is palpable, leading to frequent, loud arguments. Laura's attorney recognizes that as long as Thomas remains in the home, the playing field is relatively level. To break the stalemate, the attorney advises Laura to file an ex parte restraining order based on a heated verbal altercation, framing the loud argument as emotional abuse and a precursor to physical violence. The execution of the silver bullet is instantaneous and absolute. Local law enforcement arrives at the marital home unannounced. Thomas is given 15 minutes to gather essential belongings and is escorted off the property under the threat of immediate arrest. He is legally barred from returning to his own home, communicating with his wife, and crucially, he is barred from seeing his children. Now, analyze the immediate macroeconomic impact of this single judicial signature. Thomas has just been thrust into a multi-front legal war. He must now hire a criminal defense attorney to handle the implications of the protective order, and he must retain a high-powered family law litigator to prepare for the evidentiary hearing that will occur in 14 days. The financial hemorrhage is staggering. Emergency litigation requires premium capital. Thomas is instantly forced to liquidate tens of thousands of dollars in stock, or drain his retirement account simply to secure the required emergency retainers for 2 separate legal teams. Furthermore, he is now paying exorbitant nightly rates for a hotel or a short-term corporate apartment in a premium real estate market, while the family court continues to require him to pay the mortgage, property taxes, and utility bills for the marital home he is legally prohibited from entering. Within 24 hours, Laura has secured exclusive use of the primary real estate asset, established de facto sole custody of the children, and forced Thomas into an unsustainable financial deficit. The family law firm representing Laura now holds all the leverage. They know that Thomas is bleeding capital from 3 distinct arteries: housing costs, criminal defense fees, and family law fees. The strategy is no longer about proving the initial allegations of abuse. The strategy shifts entirely to weaponizing Thomas's financial exhaustion. As the date for the formal evidentiary hearing approaches, Laura's legal team will initiate settlement discussions. They will present an offer that essentially holds Thomas's relationship with his children hostage. The proposition is simple. Laura will agree to drop the restraining order, allowing Thomas to avoid the risk of a permanent mark on his record that could destroy his corporate security clearances, but only if Thomas agrees to a highly disproportionate division of the marital assets and concedes primary physical custody of the children. This is a coerced settlement disguised as a legal compromise. The American divorce attorney sector heavily utilizes this exact methodology because it is incredibly efficient at bypassing years of standard discovery and litigation. It forces the targeted spouse to capitulate under the crushing weight of simultaneous legal and financial ruin. Even if Thomas chooses to fight and successfully proves at the evidentiary hearing that the allegations were entirely fabricated, the financial damage is already done. The $50,000 he spent defending himself is gone, transferred seamlessly into the legal economy. The family court rarely sanctions a spouse for filing a baseless protective order, operating under the guise that punishing false claims might deter actual victims from coming forward. Therefore, there is virtually zero financial risk for the accusing spouse to deploy this tactic, and infinite potential reward. This systemic loophole creates a highly predictable revenue stream for both family law practitioners and criminal defense attorneys. It mandates the rapid mobilization of legal resources, requiring paralegals to draft emergency subpoenas, private investigators to gather witness statements, and attorneys to prepare for high-stakes cross-examinations, all billed at premium emergency hourly rates. The marital estate is systematically hollowed out to fund this manufactured crisis. But this tactical warfare is only effective when the targeted spouse has liquid capital to drain. What happens when the underlying marital wealth is locked away in complex, illiquid structures? What happens when a high-net-worth couple possesses a sprawling portfolio of commercial real estate, international holdings, and private equity investments that cannot simply be sold on the open market to pay legal fees? When the standard extraction methods fail due to a lack of immediate liquidity, the family court system activates its most draconian economic mechanism. You are about to discover how the judicial system physically seizes control of a family's life work, utilizing court-appointed receivers to force the liquidation of private empires. Enter the absolute pinnacle of state-sanctioned wealth redistribution, the court-appointed receiver. When analyzing the macroeconomics of the American divorce attorney sector, we must address the reality of illiquid, highly complex marital estates. When dealing with massive, privately held wealth, think regional car dealership networks, multi-state commercial real estate portfolios, or specialized manufacturing plants, liquidity is incredibly rare. The wealth exists strictly on paper, tied up in inventory, real estate, and operational machinery. If a divorce stalls because the spouses cannot agree on a valuation, or if one spouse accuses the other of intentionally depreciating the business to lower the eventual buyout price, the court reaches for its ultimate, nuclear economic weapon. A receiver is a private individual, usually a senior attorney or a specialized corporate restructuring officer, who is granted unilateral, dictatorial control over the marital business by a family court judge. They literally step into the shoes of the chief executive officer. They hold the unquestionable legal authority to seize corporate bank accounts, fire long-standing executive management, halt shareholder distributions, and ultimately, sell off the company piece by piece. You must understand that this is not a public service or a neutral governmental function. This is a hyper-lucrative private enterprise. The receiver does not work for free, and they absolutely do not work on a predictable flat fee. They bill by the hour, frequently commanding rates north of $800 to $1,000 an hour in major metropolitan markets. But the receiver is just the tip of the spear. Once appointed, they have the legal mandate to hire their own separate teams of forensic accountants, specialized tax attorneys, and independent property managers, all of whom also bill the marital estate at premium hourly rates. This creates a terrifying parasitic ecosystem that feeds directly on the gross revenue of the business before a single dollar of profit is realized by either spouse. Let us examine the catastrophic potential outcomes of this process through a highly specific case study in the current year of 2026. Imagine Richard and Margaret, a high-net-worth couple based in Dallas, Texas. Over 30 years of marriage, they have built a sprawling, highly successful empire of heavy equipment leasing companies and industrial warehouses. Their net worth on paper is an estimated $45 million. However, the business is highly leveraged, relying on constant, aggressive cash flow to service commercial debt and maintain the massive fleet of machinery. They are phenomenally asset-rich yet relatively cash-poor. During the deeply contentious divorce proceedings, Margaret's legal team realizes they need leverage. They formally allege that Richard is intentionally mismanaging the leasing contracts and deferring crucial maintenance to artificially depress the company's valuation before the final trial. They file an emergency motion for the appointment of a commercial receiver to take over the daily operations of the entire empire, citing the immediate need to preserve the marital estate from gross mismanagement. Historical trends in high-net-worth family law demonstrate that courts are increasingly willing to grant these drastic motions when complex corporate structures are involved, fundamentally prioritizing the perceived preservation of the asset pool over the actual operational efficiency of the business. The moment the judge signs the order, Richard is immediately and legally locked out of the corporate headquarters he built. The receiver takes the helm. The economic devastation begins instantly. Within the first 30 days, the receiver bills the estate $60,000 simply to review the intricate corporate structure and familiarize themselves with the ledger. Recognizing their own lack of specific industry knowledge in heavy machinery leasing, the receiver brings in an independent, third-party auditing firm, adding another $40,000 monthly operational burn rate. The business, suddenly stripped of its visionary founder and suffocated by a thick layer of highly cautious, risk-averse legal bureaucracy, begins to bleed cash at an unprecedented rate. The receiver is not an entrepreneur. They are a risk manager acting under the watchful eye of the court. Therefore, aggressive expansion plans are immediately halted. Long-term clients, sensing instability and frustrated by the sudden corporate paralysis, begin jumping ship to competitors. Employee morale plummets and key salespeople are poached by rival firms. Meanwhile, the crushing commercial debt obligations remain completely unchanged. The company is experiencing a manufactured, localized recession driven entirely by the litigation process. When the company inevitably fails to generate enough excess cash to pay the receiver's exorbitant monthly invoices alongside the standard operating expenses, the receiver exercises their ultimate, terrifying power. They petition the family court judge for permission to liquidate capital assets to cover administrative costs. This is the absolute death spiral of the marital empire. With the stroke of a pen, the receiver begins selling off prime industrial real estate parcels and top-tier heavy machinery at steep, fire sale discounts to opportunistic private equity firms waiting on the sidelines. The receiver is not financially incentivized to maximize the sale price for Richard and Margaret. Their primary, immediate legal mandate is simply to generate enough rapid liquidity to cover their own court-sanctioned fees and stabilize the remaining, shrinking asset pool. The wealth transfer that occurs during this phase is staggering. A $45 million legacy is systematically cannibalized from the inside out. Millions of dollars are permanently transferred to the receivership team, the auxiliary accountants, the corporate liquidators, and the original divorce attorneys who continue to heavily bill their clients simply for monitoring the receiver's destructive actions. By the time the final divorce decree is issued 18 months later, the once thriving business is a hollowed-out shell. Richard and Margaret are left fighting bitterly over a tiny fraction of their original wealth, entirely depleted by the very judicial system designed to equitably divide it. This is the harsh, uncompromising reality of the macroeconomics of divorce when massive private equity and illiquid corporate structures are involved. The state creates a localized financial crisis, mandates the hiring of incredibly expensive private contractors to manage that crisis, and forces the family to foot the bill until total financial capitulation is achieved. This wealth extraction mechanism is devastatingly effective when the assets are bound within the borders of the United States. The jurisdiction of a state family court judge, backed by local law enforcement and domestic banking regulations, is absolute within their county lines. They can freeze domestic accounts, force the sale of local real estate, and seize local businesses with near impunity. But what happens when the money simply vanishes from the domestic grid? What happens when a highly sophisticated, ultra-high net worth spouse anticipates the marital dissolution years in advance and begins executing a strategy of aggressive, international asset protection? We are about to cross sovereign borders and enter the impenetrable, shadowy world of offshore asset protection trusts, Caribbean banking secrecy, and the ruthless jurisdictional warfare that renders American family court judges completely and utterly powerless. When an ultra-high net worth individual, specifically those possessing decamillionaire and billionaire status, anticipates a marital dissolution, they do not play the highly localized, attrition-based game of temporary orders and court-appointed receivers. They recognize that the American family court system is fundamentally a massive, state-sponsored wealth extraction engine, and their immediate macroeconomic response is to remove their capital entirely from that engine's geographical reach. To comprehend this strategy, you must understand the absolute, hard boundary of an American family court judge's power. A judge sitting in a county courthouse in Manhattan, Chicago, or Los Angeles possesses near-dictatorial authority over assets located within the borders of the United States. They can seize domestic real estate, garnish domestic bank accounts, and force the liquidation of domestic corporations. However, that judge's gavel carries absolutely zero legal weight the moment you cross international waters into sovereign jurisdictions that actively and constitutionally refuse to recognize United States civil judgments. This is the multi-billion-dollar shadow industry of offshore asset protection, and it serves as the ultimate checkmate in the business of high-stakes divorce. Let us thoroughly examine the mechanics of the most impenetrable financial fortress on the planet, the Cook Islands Asset Protection Trust, operating in the current economic landscape of 2026. The Cook Islands, a self-governing nation located in the South Pacific, has explicitly engineered its entire legislative framework to attract immense foreign wealth by offering absolute legal immunity from foreign creditors, which explicitly includes angry ex-spouses and furious American family court judges. Imagine a highly specific scenario involving a tech entrepreneur named Arthur and his wife Victoria, residing in Silicon Valley. 3 years before the marriage begins to openly fracture, Arthur quietly liquidates $20 million of vested tech equity. He does not hide this capital in a domestic shell company. Instead, he legally wires it to a specialized trust management firm operating physically in the Cook Islands. He establishes an irrevocable trust, names a Cook Islands trust company as the sole legal trustee, and names himself as a discretionary beneficiary. The upfront cost to simply draft this architecture easily approaches $100,000, with tens of thousands in annual maintenance fees, firmly cementing this as a premium financial product inaccessible to the general public. When the American divorce proceedings eventually commence, Victoria's high-powered legal team immediately executes standard discovery protocols, spots the massive historical wire transfer, and aggressively demands that the family court judge order Arthur to repatriate the $20 million for equitable division. The American judge eagerly signs the order, commanding Arthur under penalty of law to bring the money back to the United States. This exact moment is where the offshore architecture deploys its most brilliant and legally frustrating mechanism, a contractual tripwire known as the duress clause. When Arthur contacts his Cook Islands trustee and relays the American judge's order to return the funds, the foreign trustee analyzes the context of the request. Because the request was made under the direct threat of judicial sanction, meaning Arthur is operating under legal duress, the trustee is legally bound by the foundational trust document to refuse the request entirely. The offshore trustee simply replies to the American court, officially stating that they do not recognize domestic United States jurisdiction and will absolutely not release the protected capital. At this precise juncture, the American family court judge is rendered completely and utterly powerless. The judge cannot send the local county sheriff to the South Pacific to enforce the order. The judge cannot freeze a bank account operating under the protection of a foreign sovereign nation. The wealth is effectively gone, legally ring-fenced behind an impenetrable wall of protective, sovereign legislation. Victoria is now facing a devastating macroeconomic reality. To even attempt to touch that $20 million, she cannot rely on the American legal system that she is currently paying thousands of dollars an hour to navigate. She must physically hire a separate, highly specialized law firm located in the Cook Islands, secure local counsel, and initiate a brand new, highly complex lawsuit in their specific foreign court system. But the Cook Islands government has intentionally rigged this international game to make foreign litigation financially suicidal. In the United States, proving a fraudulent transfer, which involves arguing that Arthur moved the money specifically to hide it from Victoria, is a relatively straightforward civil matter requiring only a simple preponderance of the evidence. However, in the Cook Islands, their domestic law mandates that Victoria must prove fraudulent intent beyond a reasonable doubt. This is the exact same, impossibly high legal standard utilized in capital murder trials, applied to a complex financial transaction. Furthermore, the Cook Islands imposes a suffocatingly brief statute of limitations on these claims. By the time Victoria even discovers the existence of the trust during the prolonged, heavily delayed American discovery process, the legal window to sue in the foreign jurisdiction has almost certainly expired. The upfront legal retainers required for Victoria to even attempt this international litigation will easily exceed millions of dollars, paid in cash, with a near-zero statistical probability of actual success. Arthur has not simply protected his wealth, he has weaponized global geography to completely break Victoria's financial ability to fight. This brings us to the true economic purpose of the Offshore Asset Protection Trust in a domestic family law dispute. The goal is rarely to permanently exile the money forever. The true goal is the creation of absolute, unassailable leverage. Arthur's domestic legal team approaches Victoria's financially exhausted attorneys with a highly calculated, ruthlessly efficient settlement offer. They openly acknowledge the $20 million offshore is completely out of reach. They then offer Victoria a guaranteed, immediate lump sum of $2 million from remaining domestic accounts, provided she signs a total waiver of all remaining claims and finalizes the divorce decree immediately. Victoria, Staring at the terrifying prospect of spending millions in unrecoverable legal fees in a foreign country she has never visited, is economically forced to accept the pennies on the dollar. The offshore trust acts as a massive, invisible shield that starves the opposing legal team into complete submission. Now you might logically ask, what prevents the furious American family court judge from simply throwing Arthur in a county jail cell for contempt of court because the money was not returned? This introduces a complex legal precedent known as the impossibility of performance defense. Historical trends in major appellate court decisions have established that a citizen cannot be held in civil contempt for failing to do something that is physically and legally impossible for them to achieve. Because the Cook Islands trustee completely controls the funds and legally refuses to release them due to the triggered duress clause, Arthur legitimately cannot comply with the judge's order, even if he genuinely wanted to. He has successfully surrendered control of his own money to a sovereign entity that ignores American law. The judge, bound by constitutional constraints regarding impossible mandates, is ultimately forced to release him. The entire system is an airtight, highly specialized, and incredibly lucrative mechanism for the elite boutique law firms that design these international labyrinths. We have now explored the absolute uppermost stratosphere of the American divorce attorney sector. We have seen precisely how the decamillionaires and the ultra-wealthy completely bypass the financial attrition of the standard family court model by aggressively exporting their capital to untouchable sovereign nations. But this level of sophisticated, international financial warfare is reserved strictly for a tiny fraction of a single percent of the economic demographic. What happens to the other 99%? What happens to the millions of middle-class Americans who are currently trapped in the hyperinflated, localized hourly billing cycles we analyzed earlier, desperately searching for an affordable escape hatch? You are about to see a massive structural disruption that is actively terrifying traditional law firm managing partners across the country. We are leaving the offshore tax havens and returning to the mainland to examine the rapid, aggressive infiltration of venture capital into the family law space. You are going to witness exactly how Silicon Valley and predictive artificial intelligence are attempting to completely dismantle the billable hour, commoditize the emotional divorce process, and replace the traditional expensive litigator with a highly efficient, subscription-based algorithm. To completely grasp this structural disruption, you must first understand the historical regulatory barrier that shielded the legal industry from modern corporate optimization. Historically, the American legal system operated under a strict protectionist mandate, known as Rule 5.4 of the Model Rules of Professional Conduct. This rule explicitly prohibited non-lawyers from holding an ownership interest in a law firm or sharing in legal fees. It was theoretically designed to protect the professional independence of the attorney and prevent corporate interests from influencing legal advice. But from a macroeconomic perspective, Rule 5.4 functioned as an impenetrable state-sanctioned moat. It completely locked Wall Street, venture capital, and private equity from deploying their massive capital reserves into the legal sector. However, historical trends over the past few years have shown a massive localized deregulation effort. States like Arizona and Utah systematically abolished this restriction, creating what are legally classified as alternative business structures. This seemingly obscure bureaucratic shift was the equivalent of firing a starting pistol for institutional investors. Suddenly, the deeply fragmented, highly inefficient $50 billion family law sector was open for aggressive corporate consolidation and technological disruption. Private equity firms immediately began executing a classic roll-up strategy, aggressively buying out successful mid-tier family law practices across these deregulated jurisdictions. When private equity acquires a family law firm in the current year of 2026, they completely dismantle the traditional pyramid structure of the legal practice. Historically, a law firm's profitability relied on a managing partner billing out a small army of junior associates at premium rates for menial, time-consuming tasks like document review, discovery indexing, and drafting standardized pleadings. Private equity operators, acting purely on financial metrics, recognize that human associates are a wildly inefficient, error-prone capital expense. Therefore, they ruthlessly replace the junior associate tier with enterprise-grade predictive artificial intelligence. This is not simple document automation or basic template generation. This is the deployment of sophisticated large language models specifically trained on decades of local family court precedents, massive troves of financial ledgers, and detailed behavioral profiles of opposing counsel and sitting judges. The AI functions as a tireless, localized legal supercomputer designed to maximize profit margins by slashing operational overhead. When a massive data dump of credit card statements, corporate tax returns, and cryptocurrency exchange logs arrives during the contentious discovery phase, the AI does not require 40 billable hours to manually highlight discrepancies. It ingests the data via secure application programming interfaces, mathematically reconciles the accounts, cross-references spending patterns against stated income to detect hidden marital waste, and flags potential offshore asset transfers in a matter of seconds. Let us examine a specific case study to illustrate the terrifying efficiency of this new economic model. Imagine Mark and Jessica, a middle-class couple living in Phoenix, Arizona in 2026. Mark is a regional supply chain logistics manager, and Jessica is a freelance commercial illustrator. Their combined marital estate consists of $150,000 in home equity, a standard employer-sponsored retirement account, and various localized consumer debts. They are the quintessential American middle-class household, and they absolutely cannot afford the standard $20,000 evergreen retainer required by a traditional bespoke litigation firm. In the past, they would be forced to represent themselves, a disastrous scenario known as pro-se litigation, heavily clogging the court system. Today, they interact with a private equity-backed legal technology conglomerate operating under an alternative business structure. There is no mahogany desk, no intimidating waiting room, and crucially, no open-ended hourly billing agreement. Mark and Jessica log into a secure, centralized digital portal. They grant the platform direct read-only access to their financial institutions using the same open banking protocols utilized by modern financial technology applications. The platform's algorithm instantly maps their entire financial existence. It automatically categorizes 3 years of transaction history, drafts the legally mandated financial affidavits without human intervention, and calculates both child support and potential spousal support, utilizing the exact mathematical formulas favored by their specific county jurisdiction. Instead of two opposing attorneys spending months trading hostile emails to negotiate a property settlement, billing hundreds of dollars for every communication, the algorithm generates a highly optimized, dynamically balanced settlement matrix. The predictive capabilities of the system fundamentally alter the negotiation landscape. The AI presents Mark and Jessica with 3 potential outcomes based on historical trends of their specific assigned family court judge. The system explicitly details the statistical probability of success if they choose to litigate specific points, mathematically demonstrating that spending $10,000 in legal fees to fight over a $5,000 depreciating asset is economically irrational. The AI forces a completely clinical, emotionally detached financial resolution. The couple pays a flat, transparent subscription fee of $2,000 for the entire unbundled legal service, completely bypassing the catastrophic financial attrition of the hourly billing model. From a purely macroeconomic standpoint, this venture capital intervention represents an existential threat to the traditional mid-tier family law practitioner. The solo attorney or the small boutique firm simply cannot compete with a massively capitalized tech conglomerate that has successfully commoditized the legal process. The traditional attorneys are increasingly left fighting over a shrinking pool of high-conflict, high-net-worth clients who demand premium, personalized hourly attention, while the volume-driven algorithm processes the vast majority of middle-class divorces with ruthless, assembly line efficiency. Private equity firms are forecasting a future where the dissolution of a marriage operates closer to a standardized financial product, akin to securing an automated mortgage or utilizing algorithmic tax preparation software, rather than a bespoke, artisanal legal battle. This technological revolution undeniably solves the informational asymmetry and cost barriers that have plagued the sector for decades. It replaces the agonizing friction of human negotiation with the cold, mathematical certainty of predictive modeling, providing an affordable escape hatch for millions. However, algorithms are built entirely on logic, optimization, and financial efficiency. They view the dissolution of a family purely as a complex data reconciliation problem, a puzzle to be solved in the fewest computational steps possible. But the human condition actively defies logical optimization. What happens when the core of the legal dispute cannot be mathematically quantified on a balanced spreadsheet? What happens when a heavily leveraged private equity firm, entirely dependent on algorithmic efficiency and rapid case turnover to satisfy shareholder demands, is confronted with the raw, unpredictable volatility of a deeply contested child custody battle? We must now examine the massive systemic vulnerabilities of the algorithmic divorce model when it attempts to calculate the value of human relationships and the terrifying legal consequences when an unsupervised predictive model makes a critical error regarding the safety and placement of a vulnerable child. The fundamental flaw of the algorithmic divorce model is its absolute reliance on quantifiable data. While artificial intelligence can seamlessly trace a hidden cryptocurrency transaction across a decentralized exchange, it cannot fundamentally comprehend the subtle, chilling nuances of coercive control, narcissistic abuse, or hidden substance dependency. When you introduce the hypervolatile element of child custody into a predictive mathematical model, the drive for corporate efficiency actively collides with the paramount necessity of human safety. Historical trends in automated judicial risk assessments clearly demonstrate that algorithms heavily prioritize historical precedent and statistical averages over the highly specific, deeply localized reality of an individual household. The machine requires digitized, verifiable inputs to calculate risk, but human trauma and domestic volatility rarely arrive neatly packaged in a verifiable data format. Consider a highly specific scenario in the year 2026. Imagine a family in Columbus, Ohio. We have Brian and Michelle. Brian is a high-functioning corporate executive who struggles with severe, unmedicated, and largely undocumented alcohol abuse. Michelle has spent a decade carefully managing this destructive behavior behind closed doors to protect their two young children and preserve his professional reputation. There are no domestic violence convictions on his record, no driving under the influence charges, and no drained bank accounts that an algorithm would mathematically flag as marital waste. When they enter the private equity-backed algorithmic divorce platform, the artificial intelligence immediately scans their digital file. The predictive model looks at the Ohio historical precedents for households with similar income brackets and zero criminal records. The algorithm mathematically concludes that a completely standardized, equal shared parenting schedule is the most statistically efficient and legally defensible outcome. Michelle attempts to input her profound concerns regarding Brian's erratic behavior and the severe safety risks he poses to the children. However, the platform's automated intake portal requires verifiable, digitized proof to alter the baseline custody algorithm. It asks for police reports, medical records, or sworn affidavits from licensed therapists, none of which exist because the trauma was entirely compartmentalized within the home. The predictive artificial intelligence dismisses her narrative as standard, unverified marital friction, categorizing it as a statistical outlier that disrupts the optimized settlement matrix. The algorithm aggressively pushes the equal custody model to expedite the case closure. The catastrophic consequence here is that the machine is entirely incapable of assessing a risk that has not yet been formalized into a government database. It operates under the highly dangerous mathematical assumption that the absence of a criminal record perfectly equates to the presence of parental competence. When Brian inevitably suffers a severe lapse in judgment while the children are in his mandated algorithmic custody, creating a highly dangerous environment, the structural integrity of the entire venture capital legal model shatters. This terrifying scenario introduces the most significant, unresolved macroeconomic crisis within the legal tech sector, which is the absolute void of liability. When a traditional human family law attorney makes a catastrophic error in a custody proceeding, they are subject to severe legal malpractice lawsuits, heavy sanctions from the State Bar Association, and the potential permanent loss of their professional license. They carry massive malpractice insurance policies specifically to mitigate this inherent human risk. But you must ask who exactly holds the legal liability when an unsupervised predictive model places a vulnerable child in immediate physical danger. You cannot disbar an algorithm. You cannot sue a sequence of code for legal malpractice. The private equity firms funding these alternative business structures operate behind massive, heavily fortified terms of service agreements. They legally classify their artificial intelligence not as a practicing attorney, but strictly as an educational software tool, systematically pushing the ultimate legal liability back onto the exhausted, legally uneducated consumer. They argue in court that the parents technically clicked the final agreement, thereby adopting the algorithm's recommendation as their own personal choice and absolving the platform of any regulatory oversight. This creates a terrifying legal vacuum where the poorest and most vulnerable demographics are subjected to automated, binding judicial outcomes without any meaningful avenue for malpractice recourse when the machine inevitably fails them. Furthermore, we must thoroughly examine the data sets that actually train these localized legal supercomputers. Artificial intelligence requires massive amounts of historical data to function. In the context of the American divorce attorney sector, that means feeding the machine millions of past family court rulings. But historical family court data is not an objective, pristine mathematical truth. It is heavily contaminated with decades of systemic judicial bias, profound socioeconomic disparities, and highly subjective localized rulings. If a specific county judge historically favored awarding the primary marital residence to the higher-earning spouse 90% of the time, the artificial intelligence analyzes that specific data and codifies it as an optimized legal standard. The machine effectively launders historical prejudice, repackaging it as an objective, mathematically sound settlement recommendation. It automates and accelerates the exact same structural inequalities that have plagued the human-operated family court system for a century, entirely shielding these biases behind the unquestionable authority of complex software engineering. The traditional legal establishment is not simply watching this technological invasion passively. A massive, heavily funded counterattack is currently underway. Elite litigation firms have recognized that the vulnerabilities of these algorithmic platforms present a highly lucrative, entirely new revenue stream. Instead of billing hours fighting over the marital estate, highly specialized appellate attorneys are now generating massive fees by directly suing the legal technology platforms themselves. They are aggressively weaponizing the concept of the artificial intelligence hallucination, meticulously documenting instances where the predictive model cited fabricated case law or fundamentally misunderstood complex state statutes. They are filing massive class action lawsuits against the alternative business structures, attempting to force the state regulatory bodies to permanently shut down the automated platforms for the unauthorized practice of law. The American family law sector has effectively bifurcated into a state of total macroeconomic gridlock. On one side, you have the deeply entrenched, hyper-expensive traditional model that relies entirely on emotional attrition, court-appointed receivers, and the relentless generation of billable hours, effectively pricing the middle class entirely out of the justice system. On the other side, you have an aggressive, venture capital-backed algorithmic invasion that treats human tragedy as a massive data optimization puzzle, stripping away essential legal safeguards and placing immense liability burdens directly onto the consumer. Neither of these economic systems is sustainable. The localized legal economy is redlining. Clients are facing absolute financial devastation regardless of which path they choose. Institutional investors are beginning to panic as traditional legal establishments successfully lobby state legislatures to roll back the deregulation laws, threatening to trap billions of dollars of tech capital inside increasingly hostile jurisdictions. The entire $50 billion divorce industry is currently standing on the precipice of an unprecedented, systemic collapse. And from the ashes of this impending implosion, a radical, completely unregulated shadow industry is quietly emerging. What happens when the American public decides to simply abandon the highly regulated family court system altogether? What happens when marriages are dissolved, complex assets are divided, and deeply personal custody arrangements are determined not by elected judges or automated predictive algorithms, but by binding extrajudicial corporate arbitrations and unalterable smart contracts executed directly on the blockchain? Welcome to the bleeding edge of the American legal economy, a rapidly expanding frontier where the dissolution of a legal marriage is no longer governed by the discretionary mood of an elected official or the aggressive billing targets of a law firm managing partner. We are witnessing the birth of the decentralized divorce. To understand how this completely bypasses the traditional $50 billion legal sector, you must understand the mechanics of a smart contract. A smart contract is not a PDF document stored on a law firm server. It is a piece of self-executing code residing on a decentralized blockchain. It is mathematically immutable, entirely transparent, and capable of holding and distributing immense amounts of digital wealth without requiring a human intermediary. Historical trends in the current year of 2026 indicate a massive surge in what are essentially cryptographic prenuptial agreements. Young, highly compensated tech professionals are entirely rejecting the state-sponsored family court system, viewing it as a massive, inefficient, and highly corruptible wealth extraction mechanism. Instead, they are opting into a privatized, extrajudicial system of binding corporate arbitration backed by unalterable code. Let us examine a highly specific scenario to illustrate the sheer macroeconomic efficiency of this new paradigm. Imagine a couple, Alex and Morgan, residing in the tech hub of Austin, Texas in 2026. They are both senior software engineers with a combined net worth of $4 million, held almost entirely in tokenized index funds, cryptocurrency, and a fractionalized ownership stake in commercial real estate represented by digital tokens. When they decide to marry, They do not hire a traditional family law attorney to draft a standard prenuptial agreement. Instead, they deploy a multi-signature smart contract on a decentralized network. This contract dictates exactly how their digital assets will be divided in the event of a separation. Crucially, they place their entire marital portfolio into a secure multi-signature wallet linked directly to this contract. They literally lock their wealth inside the code. 5 years later, when the marriage irreconcilably breaks down, Alex and Morgan do not file a petition in the Travis County Family Court. They do not pay $20,000 evergreen retainers, they do not undergo 18 months of grueling, weaponized discovery, and they absolutely do not hire forensic accountants to trace their assets. The assets are already perfectly traced on a public immutable ledger. To trigger the divorce, they utilize a decentralized arbitration protocol. This is an entirely private, borderless network of highly specialized, anonymous legal arbiters who are financially incentivized by cryptocurrency to resolve disputes rapidly and impartially. Alex and Morgan submit their cryptographic evidence and their original smart contract to the arbitration network. The network reaches a consensus based strictly on the pre-programmed parameters of the contract, entirely devoid of emotional manipulation or the threat of a silver bullet restraining order. Once the decentralized arbiters reach a verdict, an Oracle network feeds that final decision back into Alex and Morgan's original smart contract. The execution is instantaneous and mathematically absolute. The smart contract automatically unlocks the multi-signature wallet and instantly routes $2 million of digital assets to Alex's private wallet and $2 million to Morgan's private wallet. The entire dissolution of the marital estate is finalized in 48 hours. The total cost of this extrajudicial divorce is a few $100s in blockchain network transaction fees and a minor percentage paid to the decentralized arbiters. The traditional legal establishment extracted 0 billable hours. The state government extracted 0 filing fees. The family court judge was entirely circumvented. The system is brutally efficient, entirely clinical, and completely immune to the economic attrition that defines the traditional American divorce. But this privatization of justice is not limited solely to the blockchain and tech-savvy engineers. The traditional high-net-worth demographic is also aggressively abandoning the public family court system. We are seeing a massive historical trend toward private, corporate arbitration in states like California and New York. When a high-profile chief executive officer or a hedge fund manager goes through a divorce, they recognize that the public court system is a massive liability. Public dockets expose their deeply sensitive corporate financials, their psychological evaluations, and their personal vulnerabilities to competitors, investigative journalists, and activist short sellers. The financial damage of a public trial can easily eclipse the actual cost of the divorce itself. To mitigate this catastrophic risk, elite legal teams actively opt their clients out of the public judicial system entirely. They draft binding arbitration agreements and hire a retired family court judge to act as a private, corporate arbitrator. The couple rents a heavily secured conference room in a luxury high-rise, far away from the decaying infrastructure of the county courthouse. They pay the retired judge $10,000 a day to hear their case in absolute, hermetically sealed secrecy. The private arbitrator possesses the exact same legal authority to issue binding subpoenas, compel discovery, and issue a final divorce decree, but all the transcripts, the financial ledgers, and the corporate valuations remain entirely off the public record. This creates a terrifying macroeconomic divergence in the American justice system. The public family courts are being rapidly starved of the filing fees and the high-profile, complex cases that traditionally funded their massive operational budgets. The public system is increasingly left to handle only the most deeply impoverished, highly volatile, and legally complex pro-se cases, leading to massive docket backlogs, collapsing infrastructure, and heavily overwhelmed state enforcement agencies. The American divorce sector has successfully fractured into 3 distinct, highly optimized economic tiers. At the bottom, you have the middle and working-class families trapped in a decaying public court system, increasingly forced to rely on venture-backed predictive algorithms that strip away their legal liabilities and treat their children as statistical data points. In the middle, you have the traditional upper-middle class, trapped in the $50 billion meat grinder of the billable hour, forced to fund a shadow economy of vocational experts, forensic accountants, and court-appointed receivers until their life savings are completely incinerated. And at the very top, you have the ultra-wealthy and the technologically elite, operating entirely outside the jurisdiction of the state, utilizing offshore asset protection trusts, private corporate arbitrators, and unalterable smart contracts to secure their wealth in absolute secrecy. You now possess a comprehensive, uncompromising macro-level understanding of the American divorce attorney sector. You have seen exactly how the emotional devastation of a failed marriage is systematically monetized, securitized, and optimized for maximum capital extraction. You understand the fundamental conflict of interest inherent in the hourly billing model, the weaponization of the criminal justice system through ex parte orders, the devastating financial impact of Title IV state funding mechanisms, and the quiet, aggressive corporate takeover of the legal tech space. You are no longer blind to the economic forces operating beneath the surface of family law. But what happens when this exact same economic framework, the privatization of justice, the weaponization of legal complexity, and the systematic extraction of generational wealth, is applied not to the end of a marriage, but to the end of a human life? What happens when we turn our macro analysis toward the deeply unregulated, incredibly lucrative corporate takeover of the American probate system and the multi-billion-dollar elder care legal sector?